We'll call 125-851, State of Kansas versus Boatwright.
Again, may it please the court, Kristen Patty appearing for the appellant, James Boatwright. I've raised two issues in the brief and I've done it a little bit, I suppose, differently. It just made more sense to the facts to put the prosecutorial error and closing argument, make that the second issue, because the first issue involves the testimony of a cooperating witness who we disagree whether or not he's an accomplice. So I'm going to start out with actually the second issue. This court in various decisions have said that a prosecutor in closing argument cannot do certain things. The prosecutor cannot comment on the fact that the defendant, when he's questioned by the police, invokes his Fifth Amendment right to remain silent. The prosecutor can't comment and call the defendant a liar or use any euphemisms, other terms that may impact the credibility of the defendant. The prosecutor cannot vouch for the credibility of any prosecution witness. The prosecutor cannot misstate the burden of proof and switch it to the defendant. And the prosecutor cannot appeal to community interests. Mr. Boatwright argues in this appeal that the prosecutor in his closing argument in this case not only committed one of those errors, two of those errors, but all five. Obviously, a lot of it comes down to how you read the words and in context. I know my colleague has accused me of cherry picking, and she reproduced, I think, at least the entire rebuttal argument in her brief for you. However, also I need to make sure that I highlight specific things that this prosecutor said. Mr. Boatwright, when he was questioned by the cops in the police station, and when he was advised that he was going to be charged with first-degree murder, he invoked his right to remain silent. And the United States Supreme Court, in an opinion called Doyle v. Ohio, and I'm saying mostly that for anybody is watching, has said that after that, you can't comment on the fact that a defendant has exercised their right to remain silent. Otherwise, that the effect on that right is going to be chilling. And so that's what, when we talk about Doyle rights, that's what we're talking about. This prosecutor said in closing argument, he contrasted it to that one witness, Keyshawn Ivory, who did talk to the police. And he said, unlike Keyshawn Ivey, who was brought down to the police station and then interviewed for several hours, the defendant has had the opportunity for months to prepare his testimony. It's making a comment on the fact that Mr. Boatwright did not avail himself at the first opportunity to try to clear his name of any culpability in this case. That kind of variation on that same statement, it also goes into the next thing. He called in several places. He called Mr. Boatwright a liar. It's something that not only has this court said that a prosecutor cannot do, it is also in our ethics rules, 3.4E, that it is prohibited. And so that's why it's not only prosecutorial error, which we've gotten away from calling it prosecutorial misconduct, but it is also misconduct in this case. He insinuated that Boatwright was a liar when he stated, "You have reason to believe that a person who gives you a story that they want you to believe or that they want you to hear that gets them out of trouble is more likely to not be telling you the truth."
And haven't we said in the past that prosecutors are permitted to ask jurors and to argue to jurors that they ought to weigh the credibility of the defendant's
Sure.
testimony? And whenever a prosecutor does that, aren't they effectively, in your words, insinuating that the defendant's story is not credible, i.e. untrue?
Well, right. And
So how do we split those hairs?
well, and certainly, a prosecutor is within bounds. So long as they're telling the jury to use the same caution as any other witness in considering the defendant's testimony, pointing out any bias affecting his testimony and making an evidence-based argument as to why other testimony were perfected poorly.
And isn't that what this prosecutor was doing?
Well, I don't want to concede that with this one statement that I just read, but that's not the only statement that this prosecutor made. He said, for example, the defendant has had the opportunity for months to prepare his testimony, to look at all of the state's evidence, the videos, the police reports, and the records. And if it were his desire, he could craft or come up with testimony. And it appears that he has testimony that sort of bobs and weaves around all the various pieces of evidence that the state has. He uses the word weave again in another place in the rebuttal argument. And you've said in other cases that you cannot use other words, caught in the web, snowing, yarn, fairy tale, fabrication, tall tale, spin. How is bob and weave any different from those other things that you've said in different cases constitute prosecutorial error? He, basically, in a more recent case, you said that it was error when the prosecutor said regarding another defendant. Now, she's had 2 years, a little over 2 years and 3 months to come up with a story about how she's going to explain that to the jury. And she had all weekend, this past weekend, to decide how she's going to respond to all of the evidence that she heard here in the courtroom that week. You said a prosecutor cannot do that. And there's really no difference in what this prosecutor did with Mr. Boatwright, and at least as far as insinuating that he was a liar. The prosecutor also may not vouch for the credibility of its own witness. And then this kind of interplays, this is where we go back to talking about Keyshawn Ivey. And the first issue, because that made more sense factually, to make it the first issue, he was an accomplice. He was given an immunity letter. And my colleague will point out to you that the word immunity isn't in that letter. But he's the guy that drove the car that was following the victim in this case, and the car from which the shots were fired that killed the victim. He is the only witness who places Mr. Boatwright at the intersection of 5th and Western when this incident took place 5 years ago this week. That's why I realize I'm kind of going back, I'm mixing up my issues now. But that's why this guy should be considered an accomplice. He wasn't just a co-defendant in another trial offering cumulative testimony. He is somebody who was promised that if he testified truthfully, and he changed his story a few times.
Why doesn't the general credibility instruction cover this? Isn't that what we're ultimately getting to? The jury has two different versions and they giving a general credibility instruction. And when it's not requested, didn't we decide that not in your favor in State v. Goins? How do you distinguish that?
Yeah, I realize that. And I guess, the big problem, this is one of those times when a client has requested an issue, and I thought it had at least had substantial merit in order to include it in the brief. There are very few cases where the accomplice that testifies has the sole evidence, the final key piece of evidence. And everything else in this case that points to Mr. Boatwright's alleged culpability, the texts that happen around the same time as the murder, the fact that the phone was wiped, that a gun with some of the shell casings from the intersection happened to be found in his house, but unlike one of the other cases, it's not like the evidence was in his pocket. This is the only person who says that Mr. Boatwright was at Fifth and Western when this murder occurred. So that's why it's a little bit different than every other case that you have, I think. And I think in some ways too, it kind of also goes back to the second issue. It explains how important Mr. Ivy's testimony was to the prosecution's ability to get a conviction in this case, because the prosecutor thought it important in closing argument to actually vouch for the credibility of this accomplice. He talks again, that a little bit, I used a little bit different words, but basically the same statement, Trump commenting that, when he was grabbed off the street and brought to the police station, and interviewed for several hours. Look at the testimony and the statements of Mr. Keyshawn Ivy, because the argument has been made to you. How many times does a person have to be dishonest with you before you stop believing them? And a couple of other statements. And I want to make sure that I get to the other part. I don't want to leave here without talking about misstating the legal burden of proof. The prosecutor said, one of the statements that he said in closing argument was, when people conspire to commit a crime like murder, they don't necessarily agree ahead of time to make it fair for the police investigating these cases. Basically, he was telling the jury, if there are any holes in this case, you have to assume that it's in my favor. That's shifting the burden of proof, and that's also not allowed. And then I'm not able to get to the final point, which is for some reason, he talked about senseless violence, and I think that that's a stoking of fear in the neighborhood sentiment. I realize I'm over time, Your Honor. I'll come up for rebuttal.
Thank you. Ms. Litfin?
Good morning again. May it please the court. The state appears by Deputy District Attorney Jody Litfin. Your Honors, I will go ahead and start with issue 2 as well, since that's the main focus, I guess, of the brief. And there are numerous claimed issues of prosecutorial error. Our position is that none of these 5 different claims, I want to say between 11 and 12 and 13 different statements are prosecutorial error. So we don't even meet the first prong. They're not outside the wide latitude. But as the backup, we have the harmless error argument if this court does find that any of these statements are error. I think in preparing for this, well, let's put it in context, right? Because context is key, and the state did say that these comments are simply being pulled out of context, isolated, and argued as error, which is not what this court needs to do. We look at it in context. The prosecutor's closing here has had 3 parts. 1, the prosecutor talked about a detailed recitation of the evidence and what the state presented, as well as what the defendant testified to. 2, the law that applied in the case, and then the concept of reasonable doubt. The first 2 parts were really focused on in the initial closing argument, and the third part was in the rebuttal closing, which is the majority of the comments that the defendant is complaining about. And during defense counsel's closing argument, it really did pick apart the testimony of Keyshawn Ivy's, the testimony of Keyshawn Ivy, his statements, because really that's how the defendant gets placed in the car, was Keyshawn Ivy's testimony. The first kind of 3 issues, the Doyle violation, the claimed calling the defendant a liar, and the vouching for the credibility of Keyshawn Ivy, I think we can kind of take those together And again, in context, if you look at rebuttal closing, the prosecutor is doing what is permissible, which is the defendant has provided testimony in this case. He's provided a theory of defense. Now you can, as the jury, look at what evidence has been presented to support that. Statements of counsel are not evidence, which he repeated over and over again. His statements weren't, defense counsel statements are not. Let's look at the evidence to support his theory. He wasn't calling him a liar. It was an evidence-based argument of the defendant hasn't produced any evidence that Jeffrey Walters was the actual shooter. And you can take into consideration when the defendant testified that he wasn't there and was at the motel, he has a bias in this case. I mean, that would benefit him to say that, but what evidence is there to support that he was actually at the motel during the time of the shooting? Conversely, let's look at Keyshawn Ivey's testimony. What evidence is there to support his testimony? Again, evidence-based argument, not simply calling the defendant a liar. Certainly not like in Papps where they did it 11 times, or in Brown where they called the defendant's testimony a story or a tale, talking about that she had the opportunity to decide what her testimony was going to be. The prosecutor here was saying, look at the evidence, look at the testimony, who does it support? So our position is that this was not a Doyle violation. And notably, the defendant testified that he did not, he invoked his right when he spoke to the detectives here. So the jury knew why he didn't provide a statement. He told them, I invoked my right to remain silent. So that's something else that the jury could consider. And then the other comments about misstating the burden of proof. Again, the state does not believe that that is what happened here in context. I'm trying to remember the exact statements that he was saying when they were claiming that he was misstating the burden of proof. I think the prosecutor there was just talking about, you have to put together some pieces here. This wasn't Keyshawn Ivey's testimony was really important, but there were other pieces of circumstantial evidence, the phone records, what Danielle Morrison said about the job done text, about Mr. Alston saying when he was saying that Mr. Payne was leaving. So there were these little pieces that put together the conspiracy, and there were these little pieces that put together the planning of the murder. He wasn't saying that it was, if we have to fill in the gaps, it goes to the state. He was responding to defense counsel's argument that, well, we don't know what's on the phone. They didn't present to us what's on the phone. Well, that's because the phone was wiped, and we explained why those things might happen. And you have to kind of put together these pieces in order for the jury to kind of figure out the conspiracy here. So we don't believe that he was misstating his burden of proof there. And then appealing to the community interest, we also don't believe that he was doing that when he was talking about senseless violence. The motive here, it wouldn't make sense for all people that the motive is, this guy kicked in my door, so I'm going to murder him. Or he's having a relationship with the woman that I'm having a relationship, so we're going to kill him. It was senseless violence. The motive doesn't ring true for a lot of people. And I don't think that was inappropriate for the prosecutor to note that. In context, we believe that the prosecutor's arguments were all proper. If this court's find that any of them are improper, we would argue that for harmlessness, number one, there was no objection, which the defense counsel does not have to object, of course, but it can be used for harmlessness. There were preliminary instructions here that the jury had about statements, arguments, remarks of counsel are intended to help you in understanding the evidence, but they are not evidence. If any statements are made that are not supported, they should be disregarded. Preliminary instruction also to the jury was to presume that the defendant was not guilty. It's the state's burden of proof. It's always on the state. And in closing, they were given those same two instructions. So we presume that the jury followed those instructions here. And then lastly, the strength of the evidence secondarily can support harmlessness here. And I can go through all that if this court wants, but it's listed in my brief as to the circumstantial evidence, as well as Keyshawn Ivey's testimony, putting the defendant there, and sort of the circumstances and timeline of the murder. And then I can go through issue one if the court has any questions about issue two. I can move on to issue one, which is the accomplice issue. Our position is that Keyshawn Ivey was not an accomplice witness here. When we're looking at this, there was no request for an accomplice witness instruction, so we're in the clearly erroneous standard, or this court must be firmly convinced that the jury would have reached a different verdict had this instruction been given. First of all, we're looking at whether it was legally and factually appropriate. It depends on whether Ivy was actually an accomplice, and our position is that he's not. An accomplice witness is a witness who testifies that he was involved in the commission of a crime with which the defendant was charged. And there are 3 points that the defendant argues support that Mr. Ivy was an accomplice witness. We disagree with all of these. First is the fact that he received this immunity letter from the DA's office. We disagree that this is an immunity letter. It's more like a letter of outlining the cooperation that Keyshawn Ivy had with the state. Importantly, it says that it appears that he was present at the scene of the shooting and drove the vehicle to attack. That was used by the assailants to attack Mr. Payne. Mere presence at the scene does not make one an accomplice. Mere presence, while something
This
is-
was more than mere presence. He was the driver of the vehicle, wasn't he?
he was the driver, Your Honor, but I would disagree that it's not
With Mr. Boatwright sitting right next to him in the passenger seat.
correct, Your Honor. But he did not, according to his testimony, he did not know that the shooting was going to happen. We also have the detective's testimony saying there's no other evidence that links him to the murder. He brought a gun with him, granted, and there was a lot of testimony, I think, in this trial about members of gangs, and I think that can be inferred that often they have guns with them. So I don't think that in and of itself shows that he knew that there was going to be a shooting. And the fact that Mr. Boatwright was the one to direct him on where to go. Mr. Boatwright was the one who received the phone call and asked him to go make a play, which he didn't say that make a play to him meant go commit a drive-by shooting or a murder. So I don't think it's, even though he was the driver, he didn't share the intent to commit the crimes. He wasn't involved in the commission of the crimes. And I would argue that it was just his mere presence being the driver. The second point the defendant argues is, I guess I've kind of hit on it, the fact that Mr. Ivy testified that he drove to the mansion armed with his gun to make a play and had previously seen the defendant with a gun. Again, this doesn't really establish that he was involved in the shooting. The defendant did direct him and ask him to go to the mansion to make a play. They all got in the car. At his direction, he drove to the mansion, and once there, the defendant said, okay, never mind, let's head back to Walter's house. As soon as he turned onto the intersection at 5th and Western, he heard the gunshots. He ducked down. He claims he had no idea that they were going to do this. Nothing was ever said before they drove through the intersection or after the shooting. And he said at the time he considered him a good friend, but in hindsight, that really wasn't true because he put him in a messed up situation. So his testimony was that he did not know this was going to happen. And simply driving there with a gun or seeing the defendant with a gun does not establish that he was an accomplice. He also didn't know about the beef between Alston or Payne, or that there was previous tension between the two. He didn't know about the situation where Mr. Payne had kicked in the door, and he had testified that he had no reason to kill Mr. Payne. And third would be what the state is considering just mere speculation that just because he was at the mansion with these same people about a month before the murder, he likely would have had to hear the planning of this murder that happened. This doesn't establish that he was an accomplice, and he testified to the contrary. He said while he was at the mansion about a month prior to the murder, he did not hear what Alston, Clayton, Williams, or Mr. Boatwright had to say. He didn't hear what they were talking about. He denied having any conversations or discussion about planning a murder. And even if this were true, this court's case law says the mere presence during the planning of a crime also does not make one an accomplice. So our position is that there was no factual basis for this instruction. It wasn't legally appropriate. It wasn't error, let alone clear error. There are 3 factors that we can go through. If this court finds that it's error, we would argue that all of these factors are present here. Whether the accomplice testimony was corroborated, it was. Whether the motivations for testifying were disclosed to the jury, which they were. The jury saw his entire 2-hour interview with law enforcement, how he kind of slowly started to talk about his involvement. And first he heard it was Mr. Boatwright, and then it was because I was there. So they were able to view that and consider it. This letter was presented to the jury as an exhibit. Also, the jury heard that he had been charged with a firearms case in a federal case and had a pending one. So they were aware of all of these things. He was cross-examined, and his credibility was attacked during closing argument. And then, as Your Honor was pointing out, this jury was cautioned about and given just the general weight and credit to be afforded to testimonial evidence, that instruction, preliminarily and at the close of evidence. So our position would be, even if this court finds error, it was not clear error considering those 3 factors. And then, of course, our position would be that there's no cumulative error here as well. So I don't believe I have any further presentation. We would just ask this court to affirm the convictions in this case.
Thank you.
Well, as my colleague said, Mr. Ivy knew. He said his testimony was, as far as I knew, I was going there to make a play. He had his own 9mm gun underneath my lap, and I don't know what that means. Was it sitting on his lap? Was it sitting under, between his thigh and the seat? Or was it somewhere on the seat? He had his own gun. I also, well, he maybe wasn't part of the kitchen debate between Alston, Boatwright, Clayton, and Williams. If you've seen the exhibits of the mansion and the kitchen area and the living room, there's like a tiny chair. There's, the opening between the kitchen and the living room is huge. It's, there's barely a wall there. He was there the whole time for 2 hours. He didn't hear them talking. He knew. And then, of course, there's what happens the next day, according to Clayton's mother, which is, I suppose there was, I think a detective maybe testified differently, but Tequila Clayton testified the next day that it was Ivy who said to Clayton, "Man, that's crazy. We got that nigger." So, he knew what was going on. He was an accomplice. And the fact that the letter does not actually say immunity, you can't say it's not an immunity letter just because it doesn't have that word in it. That's not the way it works. Also, the comment about they don't necessarily agree ahead of time to make it fair for the police, that couldn't be in a response to anything that defense counsel had said in closing argument, because defense counsel hadn't gotten up yet. That was in the prosecution's open, and I never know what to call it. I call the first part closing and I call the second part rebuttal. So the prosecutor's closing argument was in that. Defense hadn't given its closing yet. It wasn't in rebuttal. The fair for the police comment was in that part. I'm not seeing any further questions. Thank you very much.
Thank you. Thank you to both counsel. The court will take this matter under advisement.